Please be seated.
So good morning, and we're back on the bench, and I'm just going to announce that we have a reconstituted panel. To my right is Justice Gabrielle Wolohojian, and to my left is Justice Robert Toon, and I've already been introduced. My name is Ariane Buno. I think that the Chief already mentioned to all of you that you have 15 minutes per side for your argument, but I want to assure you that we've read everything that you have provided to us, and so you can get right to your most salient points once you arrive at the podium. So the next case we're going to hear is Commonwealth versus Thomas Tilson, 2022-0889. Good morning, Counselor.
Good morning. Good morning. May it please the court. My name is Megan Siddle, and I represent the appellant Thomas Tilson in this case. Mr. Tilson's conviction turned on the admission of a guardianship decree that the Commonwealth, very much to its credit, now acknowledges was inadmissible, and an involuntary statement that Mr. Tilson made only after police detectives implied that he would not be charged if he admitted to a sexual relationship with his neighbor, provided that relationship was not forcible. I'm going to start with the guardianship decree because that issue has been narrowed in light of the Commonwealth's brief. So the remaining question
Let me just ask you, we're not required to accept the Commonwealth's concession, are we?
No, you're not. And if the court has any questions as to the admissibility of the decree.
I did notice a similar decree was introduced into evidence without objection and relied upon by the Supreme Judicial Court in Commonwealth versus St. Louis. I was wondering if you had any comment about that.
Yeah, I think in that case there was no objection to the admission, unlike here where the trial counsel did object. And I think the primary issue is that the decree was not attested to, so it was not an official attested copy. It's unclear to me whether in St. Louis that was the case or not.
I have a question about, I'm going to forget the section number of the statute. Is it section 76? Yeah, chapter 233, section 76.
Uh-huh.
That's the statute that you point to requiring the attestation of certain public records.
Yes.
Has that statute ever been applied to court records?
To court records. I believe it has. I don't have a case off the top of my head on that.
Because I looked at the language of the statute. I mean, maybe we can turn to that together.
Sure.
And it doesn't seem, it's the Commonwealth, it's divisions, municipalities. I love this iPad, except when I can't find what it is that I'm looking for, which is right now, for example. It doesn't seem to me to extend
Page 79.
to branches of government. Maybe we can look at that, if I could find it.
Page 79.
Yeah, it's on page 79 of the addendum to my brief.
Oh, I'm in the wrong case. That would be a start. So, can we look at that? I'm sorry, together. So I see copies of books, papers, documents, and records. That would be this. In any department of the Commonwealth. So the judicial branch is not a department. Or of any city or town. Branch is not a city or town. And my question is there any case that has extended Section 76 or applied Section 76 to court records?
I don't have a case that's extended this section to a court record.
So let's say that it doesn't apply. Then what?
So I also cite to Section 803 of the,
This is a regular hearsay, so it didn't come in
Yes.
as a proper business record
correct.
because there was no keeper of the records to authenticate it or introduce it.
Correct.
Can a business record be, under a hearsay exception, be introduced by a percipient witness who's not the keeper of the records?
I would think not.
You have a case.
I don't. I just know that in my experience previously as trial counsel, it's always been admitted by a keeper of the records. or with a certificate from the keeper.
And it did come in here through the brother.
Yes, it did.
There's no real question about its authenticity.
Correct.
So, but I guess what I noticed that in St. Louis, there was someone who testified to the underlying facts found in
Yes.
the decree, the guardianship decree, and we don't have that here, and that might be a critical distinction.
I do think that's a critical distinction. I would also note, as I argued in my brief, that there's a portion of the guardianship decree that I think is the key part the Commonwealth is relying on, that is effectively an evaluative opinion of the court. And so under Mattoon versus Pittsfield, cited in my brief, and under Nardi, those evaluative opinions are not admissible as well.
Well, sorry, go ahead. Even assuming that the omission of the decree was error, what is the prejudice? Because the victim's brother testified at length that his brother was in the care of DDS, he couldn't drive, couldn't shop, and he testified without objection that his mother and then him were appointed as guardians after proceeding in the probate court. So all that came in without objection. What's the extra prejudicial value of the actual decree coming in?
Sure.
When you consider all that other evidence in the case?
Yes, I see 3 points of prejudice here. The first is that the guardianship decree goes a bit beyond the evidence, the testimony from witnesses at trial about the degree of the complaining witness's impairment. So, for example, the brother testifies that he was diagnosed with, quote, mild retardation. The language of the guardianship decree is much more severe. It says he was, quote, mentally retarded to the degree he's incapable of making informed decisions. I also note the brother and the sister-in-law testify at trial that, they take care of the complaining witness's finances, but there's also some mitigating testimony that, he has a job, he's able to take the bus for himself, for example. But the guardianship decree is a little more severe. It says, quote, that failure to appoint a guardian would
I'm going to
create...
interrupt you just for 1 second. I think we haven't.
I've been told to move.
Right. Apparently, we're not recording properly because that's the microphone that's working. So sorry to interrupt your train of thought there.
Okay, no
Keep
problem,
going.
Your Honor.
Keep going.
So the guardianship decree says, quote, the failure to appoint a guardian would create an unreasonable risk to the ward's health, welfare, and property. The second reason I think the decree was not harmless is that it's the guardianship decree itself that spells out exactly what a guardianship means. The trial testimony doesn't really do that. So it's the guardianship decree that says that, for example, the complaining witness is incapable of making decisions for himself.
Well, as to financial affairs, right? That was sort of, it's a kind of limited decree as to financial affairs, not to all aspects of behavior.
Well, it also says that the appointment of a conservator would be insufficient to eliminate a risk to the complaining witness's health, welfare, and property. So it's a little bit broader as I read it. And the third reason I think the decree was not harmless is that it's the only sort of official-looking evidence that has, it has an imprimatur of a court finding as to the degree of the commonwealth of the complaining witness's degree of impairment. There's no medical testimony in this case. There's no one from the Department of Developmental Services testifying. And I also think unique among the cases that I've found, in this case, the jury was not in a good position to judge for itself the degree of the witness's impairment because there's testimony that his condition has worsened since the time of the alleged offense when he's living independently. Now he's in a 24-hour group home.
Could you clarify the standard review for me for just a moment? Because if you refer to the introduction of the decree as being objected to, and so it's a prejudicial error. But at trial, am I correct that the only objection to the decree involved authenticity, not anything else? Am I correct about that?
That is my memory as well, yes.
So if that was true, then there was no objection with respect to the content of the decree or the information that was contained therein that you've just aptly summarized for us.
Sure. I believe trial counsel did use the term hearsay, which I think would also cover the evaluative opinion issue, although she did not use evaluative opinion as a term. So unless the court has any more questions on the decree, I'll move on to a different issue.
I have a question about the verdict slips.
Okay.
Are the verdict slips, I couldn't find the verdict slips in the record. Am I correct that they're not there?
That's correct. I did not put them in the
Okay,
record.
so as to the rape convictions, was there any indication on the verdict slips as to which theory of lack of consent the convictions were based? In other words, whether it was incapacity or lack of consent in fact?
No, the verdicts didn't specify
Okay.
on that point.
It would be very helpful to me if you could supplement the record with the verdict slips
I will.
for all of the verdict slips.
I will. The court should also vacate Mr. Tilson's conviction because his trial was tainted by the admission of an involuntary statement that he made to police. The primary issue that I see with the statement is the repeated use of minimization or implied leniency. So I count at least 10 separate times during the course of a relatively short interview that police make statements suggesting either that sexual activity between two adults is fine as long as it's consensual, or that they just need to know that it was not forcible. They say things like, you guys were adults and that's fine, or two adults is two adults. Gets a little bit more forceful when police return to the room, at which point Mr. Tilson says something along the lines of, you're saying I, quote, forced it on him because of his mental capacity, which detectives then expressly deny. They say, that's not what we're saying. We want to know whether or not somebody was forced.
Didn't he actually say, people are saying, wasn't that the comment he made at that time to the police when they came back in? People are saying I forced him. And the police said, well, we're not saying that. Is that right?
I think that's right, yes. But the implication of the force of the detective's statements to Mr. Tilson is that he won't be in any trouble as long as he admits he engaged in a sexual activity with his neighbor, and as long as he says it was not forcible, which is precisely then what he does when he says, yeah, we did get together, but it wasn't forcible. So that admission is tied very closely in time to the minimization tactics, and it's also directly shaped by those tactics.
You would agree that there was no promise of certain kind of treatment given or leniency or outcome, correct?
Correct. There was no explicit promise, but
How is it that this can't be seen or couldn't be seen as sort of just a tactic by the police to offer maybe a psychologically more acceptable prompt to the defendant to be truthful?
Well, I think it's a little bit closer to the statements in Digium Batista, I hope I'm pronouncing that correctly, where police sort of give this alleged arsonist two choices. Either you committed the arsons without intending to hurt anybody, or it was by accident, or maybe you were just stressed and had been drinking. But the implication of both of those choices is that, in fact, the defendant is the one who had set the fires. It's very similar to the choice that's presented to Mr. Tilson here. Either you had sex with him and it was consenting, or you had sex with him and it was forcible. But either way, Mr. Tilson is acknowledging the sexual relationship. So I think it's a lot closer to that, with the implication being, if you admit that you did have sex with your neighbor, but it wasn't forcible, there's nothing wrong with that. And in fact, I think police are expressly refer to that as, quote, fine. So I think it goes a little bit further than just encouraging him to tell the truth.
Well, what exactly is the rule when it comes, what are the police allowed, what are they not allowed to do that would render a confession like this involuntary? What exactly is the problem from your perspective?
They're not allowed to imply that he would receive lenient treatment if he confesses against his will. And there's another issue here, which is that they're also making false statements to him over the course of the interview, which compounds the problem here. So one of the false statements is that, he's not in any trouble, when in fact they've already decided to charge him. But they also make repeated...
Wasn't it, you won't be in any trouble if it was consensual and if it was just the two of you, correct?
That, they do make statements like that. At the very beginning, they say, you know, you're not under arrest, you're not under any trouble, and it's not qualified in that manner at the very beginning. So, and they also make statements, you know, saying 2 adults is 2 adults, and that's fine, implying that police believe that the neighbor is someone who's capable of consenting. But that's actually false. At that point in time, he's been interviewed, and police have already decided that they believe he wasn't capable of consent. So those together, I think, really compounded the problem.
You only have a minute left, and one of the issues that I think is an important one is the lack of a humane practice instruction here.
Yes.
Which was not asked for, and the jury instructions were not objected to, so we agree that we're looking at this as a substantial risk of miscarriage of justice, right?
I don't, because, and that's because under Parham cited in my brief, an objection at trial to the voluntariness should be enough to preserve the issue.
So
Where was that? Sorry.
Parham, there's a Commonwealth, there's Parham.
Parham, yes.
1984, right. And so that's your understanding, is any time that there is an objection to voluntariness in the proceeding, a humane practice instruction must be given to the jury, even if the defendant doesn't specifically request a humane practice instruction. Is that you think that's the law?
I think it has to be objected to, and it has to be a live issue at trial.
Okay.
So an objection's not enough, but it does have to be a live issue, and I think a detail in my brief why it was a live issue here.
But just to be clear, defense counsel did not bring that issue, file the motion limine, but that was not based on voluntariness. It was just based on the fact that the statement was not probative and prejudicial.
The written motion in limine,
Correct.
correct. At the final pretrial conference, this is pages 14 and 15 of volume 1, it becomes a bit more clear that defense counsel is asserting a voluntariness issue, and
I'll
the trial
look
court
at that
understands it
again.
as such. Thank you.
Before you go, any further questions?
No, thank you.
Are you sure? Any further questions? No further questions. Thank you very much.
Thank you.
Morning, Your Honors. My name is Rob Kidd, K-I-D-D. I represent the Commonwealth in this matter. I will start, unless the court wants me to start somewhere else, with the voluntariness issue here in the interview.
I will say that I just looked at page 14, and it does say voluntariness and sufficiency of Miranda, so that is clarified.
Okay, thank you. So just to step back here, just have one second here. So involves the totality, and the totality of the circumstances include things such as the defendant's age, his education, the details of the interrogation, whether or not Miranda warnings were cited, whether or not there was any coercion, the defendant's emotional stability, his experience with the justice system, his physical and mental condition, et cetera, the initiator or the discussion of a deal for leniency, and the details of the interrogation, including the Miranda warnings. So applying those factors here, and again, we're here to determine whether or not this defendant's will was actually overborne by these 2 officers. Applying those factors here, we have a defendant who is 61 years old at the time of the interrogation. He has a high school diploma. He drives himself to the police department. He's not in custody. He sits down for this interview. It's approximately an hour long. The interview, as I said in my brief, is actually cordial and polite and not threatening, not overbearing. The defendant is not under any emotional stress or visible stress during the interview.
But then they take a break, and they come back, and they start the line of questioning that the defendant's pointing to here, which is not really questioning in some sense. It's laying out alternative avenues of explanation for the conduct, but assuming that the conduct occurred, and implying that one avenue of conduct is not a problem, and another avenue of conduct is. And isn't it, without trying to decide, and it's after that the defendant then decides to confess along the lines of the less serious, of what the police have just offered as not a problem, right? The lines that's not a problem. Why is that not at least open to a factual determination by the jury as to whether or not that was the cause of the confession? Because if it was the cause of the confession, that's what we would mean by will being overborne, correct?
Yes.
So I think that's the nub of the humane practices argument, is that question. And so why isn't there enough there to say that the jury should have at least been entrusted with that task?
Well, so I'll answer the question, but just reframing it in terms of we are looking at whether or not the judge abused his discretion in making a call that there was no problem with it. Remember, there was a prior motion to suppression hearing.
Right.
and a
I
prior
think that
judge-
I don't see an error with. That in that context, the judge made a determination that it's not inconsistent for a determination on a motion to suppress that a statement is voluntary. But then later, the judge gives voluntariness still is a live issue at trial, and the judge gives a humane practices instruction to the jury, right? That can happen. That happens not infrequently.
Mm-hmm.
So why shouldn't it have happened here?
Well, the judge in this case, we know he actually looked at the videotape himself. And I would just assert all the factors that the judge presumably, took into consideration when he looked at it. This defendant was not unsophisticated. He wasn't. I would suggest he knew walking in there or he knew during the interview before they took a break and started the tough questions. He knew what he did was not appropriate. If it was appropriate, he would. First of all, if it was appropriate, this defendant wouldn't have used this ruse of checking for ticks to engage in this sexual activity. So the judge had that in front of him. The judge also there's also a part of the interview, if you look at it, where the police actually start saying to the defendant, and this is before the break, they said, what if somebody of a limited ability like this defendant, so what if you were or someone was to coerce them into sexual activity or use their intellectual disability to engage in sexual activity with them? That's on page 35 to 36 of the record appendix. And then they say, would that be wrong? Would he be guilty of something? And the defendant concedes, basically, yes, he would. And I'm paraphrasing, so don't.
No, they asked him a series of They asked him a series of hypothetical and asked him to give essentially a legal opinion on what would be the outcome of those series of facts. I saw that.
Correct.
And that did not cause him to confess.
I'm sorry?
And that line of questioning did not cause him.
Correct.
We can say that line of questioning did not overbear his will.
Yes, and I think the judge had enough in front of him with all of the evidence that I just cited, with the defendant's age, his education, and so forth, and all of those factors to say that his will was not overborne and that there was no reason to submit this to the jury, that this was not a live issue.
The humane practice rule only kicks in after a judge concludes that the confession can come in. So it's a premise that the judge has already found voluntariness. The whole concept of the humane practice rule is that the jury has reconsideration of that issue and is allowed to consider that, but has to be instructed on the issue, right? So I don't find the fact that the judge found voluntariness as any kind of barrier to humane practice application, right? The humane practice exists to provide a second reconsideration of the issue. So the question is, why wasn't it error for the judge not to instruct on that, particularly after the defendant had raised voluntariness as an issue?
I understand the question. I'm not saying that the judge, what I'm saying is it has to be first of all, that it has to be a live issue at trial. So there has to be a determination that this was an actual issue at the trial, his voluntariness. And that was never brought to the judge's attention except for a brief statement by the defense attorney in her motion in limine at the trial that, you know, they knew they were going to arrest this guy, but when they brought him in, they lied to him, and then they arrested him at the end, and the statement wasn't voluntary. And the judge said, okay, I'll look at it, I'll look at the tape, and I'll take it into consideration. So I suggest to you this was not a live issue based on all of the factors that I cite in my brief regarding the voluntariness. I suggest that the judge looked at those factors and said to himself, yeah, there's not enough here. It doesn't meet the live issue test. Nobody's bringing it to my attention. Is
live issue satisfied by preservation?
No.
What makes it, have we articulated a legal test for determining whether something is a live issue at trial?
As far as I can tell, and I've done the research, I don't believe that there is a
Why
test.
isn't preservation enough?
Because in that case, you know, if you carry that to its logical extreme, I can object to the most benign statements during trial, and the judge is forced into giving a voluntariness instruction. That would not make sense to me. If there's absolutely zero evidence of coercion, just objecting to it shouldn't trigger the rule. There has to be some sort of gatekeeping, and I think that's what the phrase live issue talks about. And live implies to me that it's an issue that's being contested, and it really is not contested except for a very brief comment by that attorney in her motion in limine, which did not focus on it.
Sorry, you would agree that the testimony by the defendant is not required in order to make it a live issue?
No.
You would not agree that?
Oh, yes.
Yes, you would
It
agree
is
with
not.
that?
Yes, I agree with
Okay.
that. Yes.
Can I switch tacks? I'd like to turn to a different topic. I'm going to focus on the issue of consent. As I understand it, the judge instructed the jury at the Commonwealth's request on two theories on consent. One was incapacity, right? That the defendant was incapable by virtue of intellectual disability to consent. And the second was no consent in fact. Am I correct on that?
Yes.
The jury were given both of those instructions, but the verdict slip did not delineate between the two, so when they returned a guilty verdict, we don't know which theory they based the verdict on, correct?
Yes, I don't have the verdict slips either, so I can't answer.
Okay,
Yes.
it would be very helpful for me. Can we take the question of legal incapacity to consent? I take it that the Commonwealth's theory is that this person's intellectual disabilities were such that he could not consent to engage in sexual activity with anyone at any time.
Yeah, yes.
Yes? Okay. So, and that would include, and that has to be proved beyond a reasonable doubt, correct?
Yes.
It's not a kind of episodic incapacity such as with intoxication or drug use.
No.
The person has, in this case, graduated from high school, lives in his own apartment, has a job, takes public transportation, seems to have a social life to some degree, and of course, I understand, has many impediments, cannot read, cannot write, needs to have a lot of daily activities, assistance with many daily activities, but doesn't seem to be hygiene, doesn't seem to need help with, at least there's no evidence that he needs help with hygiene, taking care of his body. And I'm wondering what proof there is that he is incapable of making decisions about his physical autonomy with respect to sexual conduct.
Well, yes. I mean, as I said, Your Honor touched on some of the evidence of his incapacity.
Sure, he has tons of trouble with all sorts of things.
Correct.
He watches pornographic videos, apparently on his own.
Correct.
He seems to have some sexual history.
Right.
He has a girlfriend.
Right.
How there's no expert testimony. What's puzzling me here, to be frank, is I'm wondering if people knowledgeable with developmental delays would have a view about whether a person with these deficits and abilities is incapable of making decisions about their about sexual matters. Because that's what the Commonwealth needed to prove, like beyond a reasonable doubt, that they are incapable on this constellation of facts. And I'm really puzzled by that.
Okay. And as I understand the question, first of all, there is no need for an expert to testify. St. Louis tells us that. There was a social worker that testified to the defendant's, incompetence to make these decisions. And I know that, this is not one of the cases that the defendant cites where there's some severe disability, but this is certainly a case where this young man, not young man, actually, he's 50, but this man, he took public transportation, for example, but there was evidence that he got lost on the bus one day and had to, he is unable to read, he can't write, he can't cook. They're afraid he's going to burn his place, his house, whatever. They're going to burn. There's going to be a fire. He has a person who lives with him next door in the apartment who checks on him, consistently.
There was no evidence that that was required. That just happened to be the case. His mentor lives in the same apartment complex.
Oh, yeah, well, I think it can be inferred. I think that the jury could infer that the reason the mentor would have been living next door to him was for the very purpose of watching over him.
If the victim was engaging in sexual conduct with his girlfriend, is the girlfriend criminally liable for rape?
Yes, if he's engaging in sexual, well, if she's competent, assuming she's apparently mentally retarded as well, but assuming, so that's a big difference, is if he's engaging with, if he has a girlfriend who is of age and competent, and he's gay and of normal intellectual ability, the consent becomes a problem there.
So the Commonwealth's position is, as a matter of law, an intellectually challenged person cannot consent to sexual conduct with a non-intellectually challenged person?
That's not what the law says. That's one factor that, I should say, that's a factor that the jury is instructed to consider in evaluating whether there's consent. But that makes it a big problem, is what I'm saying.
I'm not asking you to adopt this. I'm just going to, if we were to conclude that the evidence was insufficient to prove beyond a reasonable doubt incapacity to consent, what happens then to the convictions, given that both theories went to the jury and we don't know on which theory the conviction rests? And specifically, I'm wondering if you want to comment on footnote 1 in Commonwealth versus St. Louis.
I'd have to look at that, Your Honor.
I'm going to bet you can answer the first question as to whether or not, if we have no, if the verdict does not indicate which theory of guilt that the jury has returned, and if we decide that one theory is not established by sufficiency of the evidence, then it has to go back.
All right, and that is what footnote 1, I think, in St. Louis implies in this particular kind of circumstance. You don't have to look at the case. But
Okay. Yeah.
I know your time is up, and I've taken a lot of your time with my questions, so
No
I don't
problem.
have
No
any
further
more.
questions?
All right.
Thank you for your attention. Thank you for answering all of our questions. Thank you very much for your arguments. They were both very helpful. We appreciate it. All right, we're going to go to our third case on the list today, which is Commonwealth versus Rene Jr. Mendez, 2023-0395. Morning,
It please
Counselor.
the court, Sean Gallagher on behalf of Rene Mendez. Mr. Mendez was indicted for perjury and 2 counts of misleading pursuant to 268, Section 13B. The alleged victim in the first count was a DEA agent, McGrath, and the alleged victim in the second count was an assistant district attorney, Matthew McDonald. Case was tried jury waived. There was a request for required finding at the close of the Commonwealth's evidence. That was denied.
Can I ask you a couple of questions about the timeline before this case was indicted, just to be sure that I have it straight, okay? Clear that your client was allegedly arrested on November 11th, 2015. The search warrant that's at issue in the case was executed on November 12th, 2015. But I want to jump ahead a little bit, and that is it fair to, is it clear that the proffer between your client that was given to Mr. McGrath, orchestrated by the ADA, did that happen in March of 2018? Was that March 9th, 2018?
To Mr. McGrath?
The proffer in the DEA office in Springfield?
Yes, I believe so, Judge.
Okay, only because there's a letter from the attorney talking about the upcoming proffer that's dated January 24th, 2018, but we have no signed or dated proffer there's no copy of the actual signed letter between.
There was nothing written down, Judge.
No, there was a proffer letter that was prepared. We have a copy of that, but it's not a signed copy. I presume that letter was signed before your client gave a proffer, but that's why I didn't know what the date was.
Mm-hmm.
So you think that was March of 2018?
Yes, Judge.
Okay. The last thing I want to be sure about is that after your client files a motion for new trial in June of 2020, his motion is allowed at the same time the Commonwealth enters a no pros on the trafficking and heroin cases. Does that happen in December of 2020 at the same time the indictment is returned? The indictment for which this appeal is from right now?
The indictment was returned before the no pros.
Okay, that was returned on December 14th. And the no pros was entered at the end of December.
True, yes.
Okay, all right. Just wanted to okay.
So I missed that. What was the process that occurred in the, I'm going to call it the underlying drug and gun case that preceded the null pros? Was there a motion to withdraw the plea?
There was.
Was that allowed, and that was allowed?
Commonwealth investigated. They came to a determination that he was factually innocent of what he pled to.
Yeah.
They then indicted him before a grand jury for the perjury and the misleading counts.
But had the defendant moved to withdraw his plea? Was that the initial thing that
Yes.
happened?
Because that's what
And
triggered
was
the
it was that
investigation by the
motion
Commonwealth.
right? Was that motion ever allowed?
It was.
Okay, so then that's how there was a null pros. Okay.
But we don't have anything written. All we have is the docket entry with respect to the allowance of that motion. Is that fair to say?
Yes, Judge.
Okay, so it was just a margin endorsement. The docket indicates that there was something mailed to the defendant, but it doesn't even indicate that there was even a hearing on it.
No, it was, I think because it was a Commonwealth's agreement that he should be released from custody, it made it, I'll just say, easier for the judge to simply endorse it.
Okay. Just wanted to be sure that there wasn't something else in the record that we don't have or wasn't
No,
available
Judge.
to us. All right. Okay, well, thank you for that. Now, to the sufficiency of the evidence, which is the thrust of your argument.
And I'd just like to note, after the court sentenced Mr. Mendez, he brought a motion to stay the execution of his sentences, which the judge, it was a jury-waived trial, granted. So, getting back to the facts.
That also happened before. When he pled guilty to the DA's complaint, he was given a month to get his things in order before he reported to
Yes, he was in for
Right.
quite a while before the motion was granted.
Okay.
So it's a different factual case, obviously. They execute a search warrant, Springfield apartment, more than 200 grams of heroin are in the apartment. There's guns in the apartment. Matthew Kendall is in the apartment. He's accordingly charged. And what happens is the case marinates in the justice system for approximately 3 years, and there's no disposition at that point, no plea, no trial. Mr. Mendez comes forward, and he said, those drugs in that search were mine.
Right.
And he does that with an attorney, and he goes to the agent who executed the warrant with other officers.
More than that, he goes also to Mr. Okendo's attorney. He speaks to 2 attorneys
Two.
about it. Right.
True, yeah, I wasn't sure whether it was just the attorneys talking among
No,
themselves. but-
that's what the testimony is, yeah.
Right. So what happens is the agent really didn't know. He couldn't tell
Well,
whether.
let me focus you, if I may, on the issue, which is whether or not the evidence at the jury waive trial, the second one in front of Judge Hodge, there was sufficient evidence to prove all 3 counts.
Now,
And the first one has to do with the information that your client gives to Mr. McGrath, DEA agent McGrath, correct?
the first count was the perjury. And
I
I
have
think,
that as the third. I think the first count has to do with
Oh.
McGrath, the second count has to do with.
I think we
the
both
ag-
treated it as the first argument.
Whatever.
Okay.
Let's just talk about the
Sure.
mislead, the indictment that charges that, in effect, your client misled the DEA agent.
Okay. So he said his statement to the DEA agent. The DEA agent passed that information along to the ADA. He did nothing else, as his testimony was. He
Does
wasn't.
he have to? Does he have to actually act upon that information in order to satisfy the elements of the statute?
No, but the law is whether or not it would be reasonably expected that the officer would pursue a material different investigation based upon that statement. And I'd submit the answer is no, because they already had Okendo locked up. You know, he's charged, the evidence is strong. So they don't have to do anything with respect to him. And then,
Don't they have to do something if somebody comes in and says, you have the wrong person, I'm actually responsible for the drugs?
no, because it's a perfect joint venture if the Commonwealth would go that route.
But that's not what your client said. He didn't say we were both involved. He said it was mine.
Well, the question, I think, would be whether a reasonable investigator, how would he interpret that? They have the drugs with him, they have the guns with him. So I think a reasonable investigator would say, well, he said they're mine, and they could also be Okendo's.
But they were both, it's not as though they ended their prosecution of Oquendo entirely,
No.
right? And we don't actually have in the record any information about what the police did or did not do after your client went and told them that he was involved with the drugs and the guns.
Well, in
So
the
for all we know, they did investigate, and they found that he owned the apartment they were in.
Respectfully, no,
We
Judge.
don't know, right?
Respectfully, no, because McGrath testified that he did nothing after that statement, no investigation of any kind. So I think that's obviously a distinction. And I think a reasonable investigator would look at it. He's 3 years coming in to make this claim.
Well, he did nothing after Mendez came up. Oh, but I see what you're saying, because they had no information to connect Mendez. We know that someone said affirmatively before Mendez came forward.
Yes,
Right, so it wasn't as though their prior investigation had found anything.
right. There was no investigation was reopened and none
Okay,
was
so what
precipitated.
difference does that make? What difference does any of that make? Are you saying that the failure to investigate is a defense to the crimes that he's charged with now?
Misleading with regard to McGrath, I would say yes, because even if you look at the statute on the misleading, it has to be an intent to impede, obstruct, prevent, delay. And none of that happened, or otherwise interfere.
Well, he did impede the investigation into Oquendo, and he achieved his purpose, which was to have Oquendo's culpability reduced and for him to be exposed to lesser punishment.
I still would submit a reasonable investigator, a reasonable DA, when somebody provides that information, wouldn't be moved by it.
It's sort of reminding me of eggshell plaintiff, or eggshell plaintiff. You take your DA as they come, so maybe he gets the DA who's not going to look too closely. So he just succeeds more easily in misleading them.
Well, the other thing that I would say, with the DA, the impede, obstruct, prevent, delay has to be with regard to a criminal proceeding.
Yeah.
That would be the plea.
Well, that could be, couldn't it, the proceeding against Oquendo? It doesn't have to be the proceeding against Mendez. I'm going to give you a hypothetical. A witness comes forward, lies to the police and that person is not a potential defendant or a defendant, but that person lies to the police in order to divert the police from the investigation or prosecution of someone else. That still satisfies the statute.
On the particular facts that we have here, I'm submitting that a reasonable investigator, based upon what was told to him, would not pursue a materially different course.
Would not pursue, you said would not pursue a material different course?
Right.
Just want to be sure I heard you there.
Right, not pursue. And
So have we ever imported I mean, here we have sufficient evidence that the investigator and the prosecutor did pursue a different course. Have we ever imported a requirement of objective reasonableness into the misleading
well,
an officer?
as I
a
understand the
crime?
law, it doesn't say objectively misleading. It says
Objectively reasonable.
Reasonable, yes. I think
That-
that's
that-
implicit.
Objectively reasonable what? What does the case law say?
An objectively reasonable investigator, based upon what was told to him,
Would be misled?
Pursue a materially different course. And
And which case is it that uses that?
that would be, pretty sure it's in Paquette. Paquette.
Well, then let's move on to the ADA. The ADA testified and said, as a result of your client coming forward, I made a decision to charge your client in a DA's complaint with a very serious crime as an officer of the court. I then gave this other person, who happens to be your client's nephew, a completely different disposition, offered him something completely different. And in fact, in the end, he got 3 days time served and suspended to the House of Correction. So he definitely did something and made a decision based on what your client said.
But what I did is I looked very strictly to the literal reading of the statute. And the statute says impede, obstruct, prevent, or delay. It doesn't say if you influence the
Well, what about
rumination.
obstruct? Isn't there an obstruction of justice here? I mean,
Well,
hypothetically,
I'll
if
say
somebody's
no.
if somebody is has been indicted and is facing criminal liability, a sentence. In this case, for example, was a number of years because it was a trafficking charge for the mandatory minimum, and that person is actually innocent, wouldn't that result in an obstruction of justice?
My argument would be that all Mendez did was augment the Commonwealth's case. It didn't change Oquendo's case, and I'd also say no reasonable prosecutor would give the deal that he gave. That's not reasonable. Oquendo was the most culpable. The guns were in there.
Well, there may be something more to this, but it does seem, as one of the attorneys said at the plea hearing, this is somewhat extraordinary, but we don't know. All we have is what was testified to, and our job is to see whether or not
May I just make my last
there was sufficient
point?
evidence there. Yeah, go ahead.
Again, on the literal reading of the statute, it has to affect a criminal proceeding. And I'm suggesting it didn't. It affected what the ADA thought, but his ruminations about what should happen are not a criminal proceeding.
It affected the ability of the judge to execute the judge's obligation under the law with respect to the plea agreement. Your client lied to the judge. He adopted factual statements that were not true. One of the judge's obligations is to ensure that there's a factual basis for the plea. Your client obstructed the judge's ability to carry out his duty.
The argument in my brief was the evidence as to whether he lied or didn't lie is in equipoise. They didn't prove that he lied.
Well, the theory under the plea is that he was in possession, not constructive possession. That was the theory that the ADA put forward to the judge at the time of the plea. And that was what the judge was acting upon.
And that's, the DA wasn't accurate in his facts. And that's what the judge acted on, the DA's representation.
Well, your client did not correct the ADA, did he? You said that's correct.
It's just, no, but
I think that I understand your point of view, and thank you for continuing the conversation a little bit. But I think we understand where you're coming from. No further question. Thank you.
Morning. May it please the court. Travis Lynch, Assistant District Attorney for the Commonwealth. With me today is Assistant District Attorney Carrie Kohler, who conducted the grand jury investigation in this matter. So just to get back to, there's that little question of the chronology. So what happened here, the background here, is that the defendant filed this motion to withdraw a guilty plea. This is at Commonwealth's Appendix 38. So you have the June motion for new trial, and then later, the defendant filed another motion, which was a motion to withdraw his guilty plea without prejudice.
So back up. Are you referring first to the fact that he filed that notice to the court and letters to the judges?
Oh, that happened before the
Before that.
motion.
So you're referring to the June 5th, 2020 motion for a new trial where he seeks to withdraw his guilty plea, right?
Right, correct.
Okay.
So,
And then there was a subsequent motion to withdraw that motion?
right, and that was entered as an exhibit during the trial. We argued it was consciousness, or I was a trial prosecutor. I argued that was consciousness of guilt because the defendant realized that he had exposed himself to the fact that he had made false statements.
When did he file that motion?
The motion to withdraw the guilty plea was August 13, 2020. So a certified copy of the drug docket was entered as an exhibit, and it's at page 34 of the Commonwealth Appendix. It was jury waived trial exhibit number 8. And then
Was that pro se as well, or at that time did he have a lawyer?
that was also pro se.
Okay.
And the defendant's motion, the drug conviction ended up being vacated on the Commonwealth's motion to vacate the defendant's conviction. We filed the 30B motion. I'm not sure if, I don't think.
His other motion was still pending.
No, he had withdrawn his motion.
He withdrew it, but
Right, the court-
let me put it this way. No one had acted upon either his first motion or the withdrawal of the motion, correct?
I believe the court had acted on the motion to withdraw the
The withdraw.
30B motion.
All right, okay.
So the defendant asked the court not to take action on his 30B motion, and then we indicted him, and then the Commonwealth filed, or I think we filed our own 30B motion, then we indicted him, but the court didn't take action on our 30B motion until later.
Right, 2 weeks after the indictment or so.
Correct.
And can the Commonwealth null pros, I just don't know the answer to this, null pros a conviction after the person's been sentenced?
Not if, I don't believe so, not if he's still serving the sentence, but I think what happened here was we filed the motion to vacate the plea and the null process at the same time. I don't think the court.
But there was never any, the court had never vacated the plea.
Right, that was just a paperwork issue.
Well,
Then we filed a subsequent null pros. There was a later null pros that was filed afterwards.
Wait,
after
After the motion was, after our 30B motion was allowed.
allowed,
We
okay.
filed another null pros.
Okay.
Though the drug case is gone.
yeah.
So-
But it was acted upon by a judge before
The 30
you did the no pros. That's what I think Judge Wolohojian is trying to
I'm
get at.
yes. concerned that
Right,
there-
we can't, I agree that the Commonwealth can't null pros a judgment of conviction because there's nothing for us to
right, you
decline
no
to prosecute.
longer have the ability to do that.
That's correct.
So I was worried, so I just couldn't figure out that the convictions had been vacated before the Commonwealth null pros them.
Yes, the drug
that
conviction did end up being vacated before the null pros took effect. That's correct.
And just to make things a little more confusing, finally the record was corrected that there was a misnomer. In other words, the charge read that it was distribution of cocaine when it was distribution of heroin.
Right.
Okay.
That was an earlier phase.
That was an
of-
earlier thing, but
Right.
that's all been corrected by now at this point, right?
Right.
Okay.
Also, it's all moot because he didn't commit that crime, or at least that's our theory of the case here.
Yes.
So there's a variety of sufficiency issues here.
Well, here's what I'd like to ask you, so we don't
Sure.
waste time.
Sure.
With DEA agent McGrath,
Yes.
right? He testifies. I listened to the proffer. It was brief. He didn't even write it. It wasn't even significant enough for him to do a report, even though he says in the testimony that the investigation is ongoing. He reports that he did nothing. So help me out with the sufficiency of the evidence on that count.
You mean with respect to the existence of an investigation?
Well, okay. Let me say that I think the evidence with respect to the count involving the ADA is different than the evidence supporting the count involving the DEA agent.
Okay.
Right. Hypothetically, let's say the panel were to decide that the evidence there is much weaker than it is with the ADA, who actually testified that he made a decision and actually made charging decisions as a result of what Mr. Mendez said. DEA agent McGrath doesn't provide any testimony along those lines.
So you're right that there was no testimony about any further investigatory steps that he took. That's correct. But I don't think that that's necessary because
Tell me why.
the point is whether or not the lies could reasonably mislead the investigation. It's not, and the whole point is whether the lies could influence how the criminal process that emanates from this investigation. I mean, that's the whole point. We're not, I don't think we're really,
So your point is that the lack of any action or any conduct or any direct consequence that we can point to is not relevant because receiving this information, in your view, is such that would cause a reasonable person to change course, and that's enough.
right, because now you have a new suspect who says, I want to take responsibility for these drugs. And that's a complete, I mean, there was testimony that the investigators had no idea about Mendez existing at all. He had nothing, he had no other connection with these drugs. The only information they had that he had anything to do with it was his lies.
Feels to me like your construction of the statute is getting a little bit close to the federal 1001 false statement.
Yeah.
False statement, right?
Yeah. Well, arguably,
Well, the fact that, I'm sorry to interrupt.
to Agent McGrath, arguably, there was a potential for a 1001 investigation.
That Yes, I mean, that may be.
But that's not our.
That's not our
Right.
issue here.
So
But
you also take this view that it's sort of an objective test, not whether something actually happened, not
Right.
subjective.
Right.
Would the fact that McGrath took that information to the DEA, would that be enough? And do you have a case that would suggest that it would be?
I think the fact that he took it to the,
ADA.
ADA,
oh, you
sorry.
meant the prosecutor. I
Yeah.
think that, I don't have a case that directly says that, but given that the whole point is that we don't want people to interfere with our criminal prosecutions, McGrath is really a conduit for the information from getting from Mendez to Mr. McDonald.
Or the other way around. McDonald
Well,
was
McDonald-
contacted
right.
with Grath, but
Right.
whatever. Yeah,
Right.
I see your point.
Right. And again, this offense may have even be, the offense of misleading may have already just be accomplished by the fact that we even had an interview. We wouldn't have had an interview at all if the defendant hadn't made overtures to Mr. McDonald because Mr. McDonald had Mr. McGrath go set up this meeting. I mean, we were misled because this meeting even happened. Mr. McGrath is misled.
Well, then let me back you up a minute, because there's something that really kind of sticks in my craw a little bit about this case, which is nobody checked to see that he was actually incarcerated at the time of this particular event.
That is unfortunate.
Before a DA's complaint was brought and he was charged.
Yes, I don't know what to say about that other than it's unfortunate that
Well,
it happened
I
this
can
way.
appreciate your candor on that, but would seem that somebody would have run that record at some point.
Well, it's also highly unusual that people come in and tell the government that they committed a drug offense that carries a significant mandatory minimum sentence.
Which would have maybe required a little bit more investigation, but that's not before us.
That's neither, yes, I understand your concern, but the point is, the crime involves lying to the government, and that's what happened here.
But the statute doesn't just require, that's not the only element of the statute.
Correct.
That's, yes. It's not just lying, it's,
That's what distinguishes it from 1001.
you are correct. The evidence at the trial was sufficient to show that the statement that the defendant owned the drugs was false. We overwhelmingly proved that the defendant was not at 23 Silver Street on November 12th, 2015. I mean, most of the witnesses established that he was incarcerated on November 12th. So I don't think that there's
What do you say, excuse me to interrupt, but what do you say about, what do you say today about the argument that, that Mr. Mendez could have constructively possessed the heroin, and therefore, it's not really clear whether or not he was misleading?
It's possible, but he also specifically averred in that earlier affidavit that he had absolutely nothing to do with Oquendo's drug case. So I think the judge, I mean, it's a fact question.
You would point to that.
Right. So the judge could credit that on the papers, but he can choose to credit that, and he chose to. And in light most favorable to the Commonwealth, that would mean that Mendez had nothing to do with the drug case. So that would seem to rule out any possibility that he constructively possessed the drugs. There are other issues, but I'm content to rest on my brief unless there's any specific questions.
I'll check. I don't have anything here. No further questions, so thank you both very much. We appreciate all of you making the drive to Boston. Thank you.
Thank you.
All right.
Taking our break?
Before the, one more? And then we'll do one more case or break? Sure. All right, we're just deciding whether or not we're going to take a break, and we're going to hear one more case, and then we're going to take a break. Now, the next cases are paired, but they're separate cases in terms of argument. So what we'll do is we'll hear the first case, and then we'll take a short break and come back and hear the second case, as well as hear the last case on the list, okay? Well, I could. I'll wait till they get up. All right, so the parties are here, and my colleague is raising an excellent point, which is, although no one has asked us to hear these cases together and to change the time accordingly, would that be your preference?
I think that makes a lot of sense, Your Honor.
Okay,
because
we'll see, then we have a good suggestion here from the bench, and that's what. Yeah, so will 20 minutes each side seem appropriate?
I think not only is that appropriate, but depending on the questions, it may be more than sufficient, because I think the second appeal raises fairly discrete and limited issues, and the primary argument will be on the first appeal.
All right, so before we do anything, I want to hear from the other side. Is that sufficient to you, for you? Okay, great, thanks. So we're going to give each side 20 minutes, and we're going to take our break after we hear this case. All right.
Good morning, Your Honors. Richard Briansky on behalf of the appellants, the defendants, and the commercial landlord in this case. The primary appeal, as we just discussed, challenges approximately $1.7 million in what we've described as penal interest, penal prejudgment interest on an award of so-called delay damages. This is how it was described to the jury and the judge, and this is also what the Supreme Judicial Court concluded, likewise on attorney's fees awarded both under 93A and by contract. The case has a very protracted history, but the issues that we've identified are limited and discrete, and I think the factual context is predominantly undisputed. In particular, a jury determined that the defendants, commercial landlords, breached the terms of the lease. The plaintiff, the tenant, then elected specific performance, which I think is significant because that's predominantly the compensatory damage, and at least the SJC has recognized that there's only limited damages you can collect when you elect specific performance. That would be the so-called delay damages, and I think that was in Donahue.
Before we get into the merits, can we address the waiver issue for all the prejudgment issues that you're raising in the first appeal? And the fundamental question here is, why didn't you seek to raise these issues in the first appeal that went up to the SJC?
And I think we answered that in our brief, Your Honor, but I'm going to basically be fairly repetitious, and I'm not sure this is going to answer your question, but we did raise it. And the judge acknowledged that we raised it. We raised it both in a motion to strike, and that was very limited.
Yeah, we're not talking about waiver on the trial court level. We're talking about appellate waiver. So, there is a line of cases that says that when a motion is left unacted upon in the trial court, and then the case goes up on appeal, that open motion is deemed to have been denied. But regardless of that, because I think that would have to be the case here, that you'd have to construe it that way. Otherwise, how could you have proceeded, anybody have proceeded with the appeal if they didn't think that everything had been acted upon down below? The real crux of the waiver issue, in my view, is that you then don't raise the arguments on appeal, right? The arguments are not addressed at all in the first appeal.
That's absolutely correct, Your Honor. And I don't think we disputed that, and we concede that.
Right.
We didn't dispute it. Not only did we not dispute it.
So how is it not appellate waiver?
Your Honor, the argument we made, and it seems that the court's not going to accept, is that essentially that Rule 59 motion preserved our rights. And
It would have preserved your rights if you sought a ruling on it in the trial court. But when you decide to pursue an appeal before it's ruled on, then I believe our cases say the motion is deemed to have been denied, even though it wasn't acted upon. And so you would need to raise the argument in the appeal.
Well, it absolutely wasn't raised on appeal, Your Honor, but I don't think that forecloses the argument altogether. Rather, the Rule 60 argument, which we did raise and the judge did find, I think is equally applicable here. And Rule 60 would allow the court to consider this issue. And when you look at the application of the interest that we're challenging, that was...
I'm sorry. The problem is that the same principle that forecloses the renewed 59 argument also applies to 60A. Now, I understand that the trial judge went ahead and granted certain relief under the 60A, and no one's appealing that now. But the same rulings that say you can't renew an issue that was on the face of the judgment during the first appeal applies to both Rule 59 and 60A. So in theory, none of these issues are viable after the first appeal and the prescript order.
With the sole exception of the SJC appellate fees, because those appellate fees occurred post-appeal.
The SJC
Yes, the
appellate.
Fees on
SJC
appeal.
awarded appellate fees, and then the court applied prejudgment interest on those attorney's fees. And
Yeah,
that occurred
that's a really interesting question. So these mandatory, these statutes that impose mandatory fee shifting, and 93A is one of them, and we have tons of cases that say that means you also get your fees on appeal. But we don't have, I believe, any case that says what happens, whether that award of appellate attorney's fees is subject to prejudgment interest or post-judgment interest.
That's correct, Your Honor, and the case law would indicate just the opposite, that that's not part of the compensatory damage, that by applying the prejudgment interest of approximately 2 years would actually be penal in nature. And I guess there's two issues. One, we couldn't have possibly known about the award of attorney's fees until post-appeal, so we couldn't have raised it prior to appeal.
Well, there may also be just an issue of authority of the courts, that can a trial court essentially operate on an award of, because it's not really a judgment. The appellate courts don't issue judgments. We issue an order that awarded fees and costs. And can the trial court, in essence, amend that? I'm not sure. I don't know.
Well, and even, at least for me, what was fundamentally problematic about the award in general was the basis of the timing of the award. The award is linked to the notice of appeal, not to the incurring of the legal fees. And we all know the notice of appeal just starts the appellate process. That's not where fees are incurred. And even if you look at Sterilite, which is one of the cases that makes this distinction that allows for the compensation of legal fees, and then we also cited a Judge Gertner opinion, which I thought was really well reasoned, although not necessarily binding on the court, which basically suggests the same thing, that when you're calculating prejudgment interest to the extent it's applicable, that prejudgment interest should only be calculated at the time the fees are actually incurred, because that's consistent with the statutory interest that's allowed.
And in your view, that would be date of payment when it comes to the attorney bills?
That's correct. It's not the date.
Why not the date that the bill is incurred, like the date that the attorney sits down and starts working on the appeal?
Either of those, because Sterilite actually says it's the date you actually pay the bill, because that's consistent with
Right.
what our interest is intended to compensate, not when the attorney actually incurs the fees. And so Sterilite but in either event, none of that evidence was before the court and the trial court. And the trial court summarily adopted the notice of appeal, and I have found a single case where they've allowed prejudgment interest based on the notice of appeal.
Can I ask you a hypothetical, which I realize is not this case? But if we were to come up with a rule, whatever that rule might be here, like a holding, what would happen in a contingent fee case if somehow there was a 151B or 93A fee shifting statute involved, and appellate fees and costs were awarded under that fee shifting statute, but it was a case taken on contingent fee, and so maybe there was even no bill sent until the conclusion of the case, but there wouldn't have been payment by the client in that case. Would the person just not get interest at all?
No, Your Honor, I would argue that it's when the fees are actually quote-unquote incurred, not when they're actually paid, because that's when the obligation to make payment accrues.
Okay.
And arguably, that is when the prejudgment interest.
So if they're writing the briefs and creating the record, even though the client's not billed for that yet, that would still be, the fee had been incurred?
Well, it's typically when it's billed, but yeah, I mean, I get what you're saying. And that's, because I know there are cases, especially fee cases that we've dealt with in the insurance context where the fee is quote unquote incurred at the time the work is performed. But even here, the notice of appeal wouldn't necessarily give rise. We all know what happens with the notice of appeal. The work is predominantly done by the appellant in the initial step. The notice of appeal is filed. Then there's a whole procedural and administrative work that goes to get those get the docket up to this appeals court, and then the work begins. So that was an arbitrary date with there's no evidence, and I understand that your question was a much broader policy-based question. But here, and I make that factual distinction because it's significant and we raised it below. I do want to, and I understand the court's position on waiver, and I'm not trying to belabor the point, but I do think it's relatively significant here where you see delay damages. They're inclusive of the interest that's being sought, and what actually happened here is punitive in nature. I don't think there's any dispute if you read the SJC what they concluded delay damages were, what the trial judge concluded delay damages were. It was inclusive of the very interest, and you're penalizing a party here. And I understand the waiver argument, but I also understand the practical significance of filing a motion, preserving the rights, and then having a judge not issue and concede that he doesn't issue a decision on the merits.
I know, but at that point, either your client needed to pursue a decision on that motion in the trial court. That would have been the ideal thing before pursuing the appeal. But in the alternative, if they pursued the appeal and they said, well, the judge never acted on it, you should deem that it was denied, and then argue the issues on appeal.
Which I appreciate, and not to belabor the point, but of course I will in this particular case, because I do think it's fairly compelling the injustice that was done, and I do recognize appeal, the finality, the whole purpose behind that, and I'm not trying to dispute that, even though I think here the judge's decision on the application of prejudgment interest really was not made known to the parties. And I get the clerk had entered several notices indicating that interest applied to everything, but those were fairly perfunctory in nature, and I think they were standard. The judge's real decision on the application of the prejudgment interest occurred post-appeal, December 6, 2022, despite what the clerk was obligated to do under Rule 54, which was to calculate the prejudgment interest. And had the clerk performed that ministerial function, which in this case was relatively substantive, which he's commanded to do under the rule, we wouldn't have had this problem. And I guess you can also say we wouldn't have had the problem had we raised it below. So I'll direct the court's attention to two other discrete issues which we've raised on appeal. The first is the post-rescript attorney's fees. We've argued that there's no justification, either statutory or contractual, for the allowance of those fees. We argued that below. We preserved the right of appeal by filing the notice timely. And what I think is significant here is just exactly what you said, finality. If finality applies to us through the appeal, then the 93A action and the contract action were resolved. And if you look fundamentally and substantively at what happened post-rescript, these were to correct predominantly clerical errors. I mean, there were, I think, 2 or 3. This is a fairly unique factual circumstance.
Why draw the line there? If, in other words, that's still part of the litigation, is it not?
I don't perceive it. It's not caused by a breach of contract. And if we specifically highlighted the terms of the lease provision, which is fairly narrow and discrete in terms of prevailing party and attorney's fees, and it was not to cure a non-monetary default, nor was it in further prosecution of 93A. There was no unfair...
But the lease in the case gave the plaintiff a contractual right to recover any and all attorney's fees and costs. Pretty broad language, right?
That's not true, Your Honor. It's paragraph 28, and that is fairly discrete. I think it said for non-monetary default, and that's not very broad. It's extremely narrow. And we argued that both on the trial level and I don't know if we argued it. No, we did not.
The lease doesn't refer to including any and all transaction costs and attorney's fees?
But what triggers the liability under the attorney's fee statute, which is the first part, it states it must be to cure a non-monetary default.
Right. So the question is, does this relate to, does the subsequent award of fees relate to the issue of default? And you're saying it has to be cut off.
It doesn't. And if you look at the substance of the motions that were filed, and this is what we argued to the court, and I'm arguing again here, but If the clerk makes an error on prejudgment interest, which there were or fails to include an attorney's fees award, how does that have to do with anything caused by a breach of lease or to cure a non-monetary?
Because there would never be, you wouldn't be in court unless there was a breach of the lease.
That's all true, but all that money and compensation was resolved through the SJC. What remained were the prejudgment interest issues and the inclusion of various awards from various courts. I wasn't, sorry. The plaintiff filed some of those motions. These weren't all defendant-driven.
Right.
And even the court recognized that the defendant wasn't responsible. I mean, the whole idea of a prevailing party is you're the reason we're here. But all of those issues were cured to the extent, and there was a monetary component assessed through judgment. Now what
So
we're talking...
basically, what I understand your argument on these fronts to be is that with the post-rescript attorney's fees and costs, there was insufficient connection with the fee awarding basis, whether it was the contract or 93A, to justify an award of attorney's fees and costs, either under the contract or 93A.
That's correct, Your
Okay,
Honor.
and is that an argument as a matter of law, or is it an argument because it's post-rescript, or is it an argument that requires us to get into, is it let's say, a mixed question of law and fact, because it requires us to look at what the nature of the various proceedings were?
I would argue that it's a matter of law, and it's triggered on the definition of rescript and what that means, and that to the extent there were additional issues, those issues were done, final, and what remained were new issues associated with these.
But it's all part of the same litigation. This entire litigation flows from the issue about the default of the lease. And so, post-rescript proceedings or not, it's all part of the same process. So I guess I don't understand how are we supposed to sort of determine when things get cut off for the purpose of overruling the trial judge's determination about the applicability of the fee provisions.
To me, it's a twofold answer. The first is I look at the substance of the motions that were filed. Are they substantive in nature or procedural in nature? And they're procedural in nature. They are predominantly based on clerical errors. That's not, and when you look at the purpose, both for 93A and the contractual provision, is to shift the burden to the wrongful conduct. And here, I think a series of those motions were necessitated by clerical errors. And I don't think there's any dispute in the record. The plaintiff was filing motions that we didn't oppose. And we opposed, this is a very protracted history, we opposed a lot of motions, but there were a series of motions that went unopposed because it was an acknowledgement of a clerical error.
You could parse those. In other words, there's maybe the whole kit and caboodle, to use a layperson's term, should not have been awarded. But if, as Justice Toon is saying, is that we're talking about litigation that if we were to conclude that flows directly from the initial breach, then some of those post-rescript motions are part of that.
I just disagree, Your Honor, because I don't think you can show the connection between the two, and without the connection, and the court also retains, and I say this in many different circumstances, but the court always retains jurisdiction even under 93A, whether to award appellate fees or not, to determine whether that unfair and deceptive trade practice is on appeal and whether they should be compensated under 93A or not. I don't know why this is not a similar circumstance. I mean, to take your argument to its logical conclusion, you'd be using that to punish people who have an appeal that have nothing to do with 93A and merely awarding it. And I understand
not necessarily. But let me ask you this, because your time is short. If we were to conclude that that the lease provisions would incorporate at least some of the activity that took place after the post-rescript, would we have to send that back to be adjudicated, or could we do that ourselves?
I think you can do that yourselves because I think it's simple. And I only have one other issue because it's very limited, and I do have a
Can I just ask before to rule in your favor on the attorney's fees issue, we have to conclude that there's no basis under either the contract terms or 93A, right? We have to rule in your favor on both of those issues for you to prevail. Is that correct?
When you say the attorney's fees issues that we're talking about,
Appeal 2, right. There's two different bases
That's
for
correct.
that finding. So we have
The
to find that neither of those two bases exist in order to rule in your favor.
that's correct, Your Honor.
Okay. And now you're going to turn to the post-judgment issue. This is the issue.
The extremely discrete issue that we believe we paid the judgment, and we believe that we satisfied the judgment. The only rights that we preserved are the rights to take this up on appeal. And we've cited some case law, and the judge said that we're going to be penalized in the form of continuing prejudgment interest to the extent we take it up on appeal, and we believe that was an error of law.
Well, we allowed you to stop the clock on the accrual of, I think it was around $17 million of the $20 million that had developed at that point, right? So it seems like the judge, once you specified that the $17 million wasn't subject to the appeal, then he said, okay, no more post-judgment on that. It was only the remaining $3 million that he's kept the clock running on. So why isn't that an appropriate resolution of this issue?
Because there's no contingency with our payment. They have the use of money, and if they have and really what you're talking about, and I look at the Governo case where they put it into like a Rule 60, where you're talking about paying it into the court, or the plaintiff or the prevailing party doesn't have use and control of the funds. Here, there really is no contingency associated with the funds, and the only contingency is one that would accrue as a matter of law, meaning that if we win, they'd have to pay it back. So we haven't imposed any restriction on the money to allow interest to continue to accrue. And we filed, there was one unpublished appeals court opinion, which we cited and attached to our brief. And I think that's a factual distinction that's been recognized by the few published decisions that we've identified.
I mean, I don't think any of these cases speak to the issue, unfortunately. That the 40 Pines case that you've relied on acknowledges that this happened, but wasn't by any means a holding, and was unpublished decision of this court. So this seems to be something that's not covered in the statute. There's no procedure, as you acknowledge, under Rule 67 to provide for stopping the clock. It seems like in some respect, this is a matter that's kind of open to the discretion of the trial judge. I don't understand where you think this is kind of a clear legal issue that requires the judge to say once the money is transferred, the clock necessarily stops, particularly when you are reserving your right to claw back that money if you prevail on appeal.
When you say claw back the money, we weren't reserving the right to claw back the money. We were preserving our right to appeal. They had the right to use the money. In the end, I prevailed on appeal. They would be required.
How's that different? Because if you did prevail, you do get the money back. How's that different? Are you objecting to the term clawback, or because the result is the same?
Yeah. Well, see, I objected to the term clawback because it implies a restriction on the funds when there are no restrictions on the funds. The only restriction that we asked is to preserve our appellate rights, which don't restrict the funds at all. It's only a recognition of law. As a matter of law, if I prevail, I get the money back. And not only do I get the money back, I should probably get interest for the time they had the money. And really what the judge did is flip the statute, because what the statute recognizes is if you have the money and you have the use of the money, you don't get interest. And that's significant here. It'd be one thing, and if you look at the cases, which I think is really significant factual distinction that I think the judge glossed over, is that we didn't say, put the money in escrow. We didn't say you can only use the money for specific things. We paid the money unrestricted. The only thing we did is preserve our right, and there should be a mechanism in place. And I understand the distinction why those courts allowed interest when the plaintiff or the prevailing party didn't get the use and control of the funds. But here, they have the use and control of the funds. So what are you awarding them other than additional interest that they shouldn't be entitled to?
I think you make some good arguments as a policy matter, and of course we're doing this against the background of a robust 12% interest rate that's set by statute. So there's certainly, I see a policy view. I'm not sure that it's actually determined by the statute or any of the case law that applies. So I guess one question is, what exactly are you seeking on this issue? What money do you think you shouldn't have paid? Is it the post-judgment interest on the $3 million that you specified was still subject to appeal? Is it something else? What exactly do you want if you were to
so
appeal?
it's the I think as a practical matter, to answer your question, there's been no money that we've paid yet. It's the money that we would anticipate paying in the event of a loss, which would be the post-judgment interest after payment. Because our position is fairly clean line that as soon as that payment was made, that extinguished the judgment itself, and the only thing that we preserved, which we have a right to preserve, is our right of appeal. It's a pretty, and I think you bring up a very good your conclusion, Lisa, I acknowledge, because I was in a position, and I think a lot of appellants are in this position where there's a significant award, and it makes sense, at least according to our rules, to make payment to avoid that interest as an additional penalty, but you still want to preserve your appellate rights. And that's something that you should be entitled to. Actually, there's no reason why the money should be paid post-appeal. There should be an encouragement to pay the money, and then if you still want to pursue your appeal.
I think we got your point. I'm just going to see if there's other questions.
Can I
Hold
ask
on.
one more
Yes.
question? Well, the primary reason that you paid this money wasn't, to me, to stop the clock on the post-judgment interest. It was to get rid of the attachment on your property, right? That was the value of you paying the money to the plaintiffs at that time. You're also asking for the secondary benefit of stopping the post-judgment interest. Isn't that correct, though? The whole reason for it was to dissolve the attachment on the property?
No, and actually, it's just the opposite. In order to get the money to pay off the attachment, in order to get the money to pay off the judgment, we needed to get rid of the attachment because we were getting conventional financing on the property, and that's what prompted the resolution. So our intent was to stop the interest. It was $20 million ticking, and this appeal, I think, lasted over a year. So the intent was to eliminate the interest.
Okay.
And in order to do that, we needed to get, so you're right, the record does show an effort to resolve the attachment, but in order to get the conventional financing, the bank wanted a first position. This isn't part of the record, but just so you have some context.
Your 20 minutes have now gone into 25 minutes, and so unless there's any further questions, I think that we'll hear from the other side, and of course, we have both briefs that you filed.
Thank you.
Thank you. We'll give you some leeway as well, if necessary, during the course of your argument.
Thank you, Your Honor.
I'm sorry, before you begin, and I'll let you go with your intro, but can you just identify the issues that you don't believe are subject to appellate waiver? And question, is it pre-judgment interest on appellate fees, post-judgment interest, and then the attorney fees issue in the second appeal? Is that your position, that those three issues are appropriate for resolution and not subject to waiver?
That's correct, Your Honor. So pre-judgment interest on delay damages we believe is waived.
Wait, can you speak up, please?
Yes, Your Honor. Pre-judgment interest on delay damages we believe is waived. It was apparent on the face of the judgments prior to the first appeal. And then with respect to the other matters, we believe that they've all been waived in one form or another because of these piecemeal appeals which are filed while matters are still below at the trial level over and over again with misleading and inaccurate civil docket statements. So we do believe that the way that this matter has been appealed
So
should have
your
just
take
been
on it
denied.
is that everything's been waived?
Yes, with the
Even
exception.
post-rescript? Even things that happened after the rescript from the SJC?
Yes, Your Honor. The way that the appeals were construed was that there was an appeal of the waived issue, prejudgment interest on delay damages, in 2023. And then after that time period had elapsed, the defendants filed another piecemeal appeal, attempting to bring in the post-judgment interest issue, even though they knew and were litigating at the time that appeal was filed. And then, Your Honor...
How would that be waiver? That seems to me like a prematurity issue rather than a waiver issue.
Your Honor, we believe that there is policy in CP 200 state that piecemeal appeals of this nature are disfavored and that the court should reject them. But I can move to the merits.
Okay,
We think the
well, I
strongest
mean, that's a different argument than waiver. We don't usually find waiver when someone's precipitously appealed.
Yes,
I
Your
hear
Honor.
you saying that there were precipitous appeals here. They kept coming up on appeal before they should have.
And adding new appeals after the briefing deadlines and so forth had passed.
But it seems like they're allowed to challenge post-rescript events that happen in the litigation, even if a similar issue could have been raised with respect to a different event earlier. If it's a new event, they seem to have a right to raise that issue in this appeal.
It's definitely a different waiver analysis. There's the first one, which is, of course, the appellate waiver, right, for the delay damages.
If you could have raised it in the first appeal, that's one thing. If you couldn't waive it in the first appeal, that seems to me like another. Justice Toon is asking you whether there's anything that, in your view, was not waived in the first SJC appeal? And if so, what are they?
Certainly the items that came after the appeal.
Everything after that?
Absolutely.
Okay.
Absolutely.
All right, so let's work on the assumption that we don't see waiver as to those. Do you want to address the merits?
Yes, Your Honor.
Okay.
So setting aside then the prejudgment interest on delay damages, all the items which certainly could have been raised in the first appeal, then coming to the time frame of after the rescript, well, we enter the challenges which are prejudgment interest on attorney's fees, and then we see the challenge to the post-judgment interest. So taking them in that order.
Right. And then the second appeal, which is the attorney's fees issue.
Correct, on
Right, okay.
the
So-
overall, the new, exactly.
Yes, right. So you're going to go first with prejudgment interest on attorney appellate fees.
Yes, Your Honor.
Okay.
So first, there's this claim that there is no prejudgment interest on attorney's fees, and there is. The courts have held that there is. Sterilite itself was a fees case where interest was applied. It's just a matter of how they would be laddered in time, because it wouldn't be fair, of course, to strictly follow the statute and attach as the starting point for prejudgment interest the commencement of the action, because those bills came due over a course of time. And what Sterilite informed was to take them on a staggered approach, a ladder, if you will. And that's why in the 5 different fees petitions throughout this litigation, and this is in Record Appendix 2, page 264, we put before the court a laddered approach, which we believed strictly followed Sterilite. Meaning, don't take the last or most recent fees petition and start the prejudgment interest way back when the case began. Simply ladder them so that it never goes back to the period where the previous fee award covered. And
But I'm looking at that, and that chart that you created is not pegged to when they were incurred. It looks like, if I'm correct, and I may be looking at the wrong thing, it looks like it's time to the dates of award as opposed to time to the dates when fees are incurred.
so each row there, so there's 1 through 9, Your Honor.
Yep.
Row 1A, 2A is the first fee award, and it contains within it the date of prejudgment interest.
Sure.
And so for that one, you'll see it's 8/9/17 to the judgment, to the award.
Right, so maybe I'm confused. I thought we're talking here about interest on an award of appellate attorney's fees and costs.
Yes, and so these are examples where, in the last one, item 9 is the one that we're talking about, really the only one at issue that isn't waived. And then you'll see in row 9A, the time period there, it doesn't go back 2 years, as my brother stated.
Oh, you're taking it from the date of the notice of appeal.
That's correct. When
Right.
the liability of the litigant to the lawyer to go read the briefs, begin the appellate work, and when the work is being done and billed.
All right, but that is not necessarily when the fees are incurred, right? Because the fees are incurred over the course of the appeal. So, for example, normally the fees are backloaded since they really are, the bulk of them are incurred on appeal in the preparation of a brief, which doesn't happen at the time of the filing of the notice of appeal. So why would we impose interest on the fees that are incurred later back to a time that's earlier? That's the crux of the argument, as I understand it.
Yes, Your Honor. That time period, in this case, where there was a jury trial and there were 2 93A trials, so 3 trials really, and a host of motions, a tremendously heavily litigated case, did incur a significant amount of time by the parties. Oh, and I might add, invocations of the Fifth Amendment, privilege issues, which were reviewed through that time period, preparing for a hefty appellate challenge by the defendants. And there was no challenge when these fees went in as to the timing of when they were incurred or when they were billed and paid. Instead, the challenge before the court when these fees were raised was whether we should receive them at all. And of course, under Sterilite and Anastos, the SJC has stated that we can. Now a challenge comes that the timing should be tweaked with respect to when those fees, the dates that they were incurred versus paid. The trial judge, however, was appropriate in moving the beginning of the prejudgment interest up to at least encompass the appellate portion of the case only, and not to stretch over the prior fee awards within the case. We believe that that is an appropriate laddered approach in line with Sterilite and should not be disrupted, and that the defendants in this appeal have not brought anything forth to challenge the dates factually or to find anything clearly erroneous within the dates, nor is there anything in the record of appendix or part of this appeal to make that factual challenge. Instead, the trial judge looked at this laddered approach and, not seeing that, receiving that challenge below, adopted it. And it's appropriate. It falls within Anastos and Sterilite. The next issue that the defendants challenge post-rescript is the post-judgment interest decision, which, as Your Honor noted, was a measured avenue, not a windfall, but a measured avenue of addressing what should we do with the remaining post-judgment interest in this case. The defendants here did, full eyes wide open, brief this issue to the trial court. It was briefed several times over with a few motions on the attachments and how, if they were dissolved, what the security would be, what the issues would be. And the trial judge appropriately provided to the defendants a mechanism to reduce post-judgment interest that doesn't exist in the other cases that we've seen where the entire amount continued to accrue.
Let me ask you, why isn't the rule that a complete tender of a judgment stops the accrual of post-judgment interest, but an appealing party gets that money back if it prevails on appeal, right? So all the money goes to you. You have the money, you have the enjoyment of the money, the damages, but they're allowed to go ahead with their appeal. They go up, maybe they win, and then they go back to you and say, oh, there's a new judgment now based on the appellate decision, and you need to return that money. Why isn't that an appropriate way to handle this issue?
Because the SJC has looked at this exact issue and looked at Davis versus Allstate in 2001, where Justice Graney looked at this issue of the tendering of the full amount. And the SJC found that any condition with that tender, any condition, will not stop post-judgment interest. And then just a few years ago, in Commerce Insurance versus Safarowicz, the defendants asked the SJC to revisit that exact question, Your Honor.
Both of those cases interpreted the post-judgment interest provisions in insurance policies, which is kind of a different issue than what we're dealing here. We're dealing with the application of the state statute on post-judgment interest, right? And I think also there was issues about conditional payments and parties being required to issue a release from liability that aren't at issue here, right? So I don't see those cases as kind of speaking with complete clarity as to what we do under the post-judgment statute itself. And I guess I'm asking, as a matter of policy and reason, why doesn't it make sense if a judgment debtor gives the judgment creditor the entire amount of money, why does the 12% interest rate keep going if just because they're saying, well, we're going to take this up on appeal and see what our chances are there? I just don't understand sort of the whole point is to put the judgment in the party that has won it, at least for the time being. So why would the 12% interest rate keep going under those circumstances?
It keeps going because they don't actually have the unencumbered funds. There's a restriction and a liability that money might be returned. They can't use it in the same way that you could use money paid without a condition. And that's why the 17 is very different than the 3. The 3 has absolute restrictions on it. It might get yanked back. You use that money with your own peril, and that has costs to it. And those costs are being thrown upon the plaintiff here, the judgment plaintiff here, which the SJC has said, and the policy answer is, in Safarowicz, we want to protect injured plaintiffs, and we want the policy to be to encourage settlements. Defendants, Justice Gantz wrote, affirming Justice Graney's and sticking with that policy, stated that that is the proper policy because the defendants hold the key to end all that interest by just ending the case.
By giving up their appellate rights.
That's correct.
I mean, it seems a very strong incentive for them to sort of not pursue an appeal.
It does.
Is that something we want to encourage through the post-judgment interest statute, or we will allow parties to pursue their appellate rights?
The basis for the interest statutes have been held exactly the first, to help resolve cases. It helps them settle it, It helps us have less appeals. It brings finality to cases, and that was cited in Green versus Philip Morris just this year by the SJC, where again, it was attacked as punitive or punishing. No, it's a meticulous application of the statutory rule that every single judgment accrues post-judgment interest. The only thing that stops that, as they said again in Governo law, is an unconditional payment. And specifically, they stated, maintaining your own appellate rights or asking someone else to give up theirs is a condition which will not stop post-judgment interest.
If you receive the money, if you're the judgment creditor and you receive the money, you can invest the money. You just can't get a return of 12% you can put in CDs or whatever and maybe earn 4 or 5%, whatever the rates are today, right? You can't actually get the 12% that you can under statute. So it's not like you have no use of the money whatsoever. You may need to return it depending on what happens on appeal. Go ahead.
You invested in a CD at your own peril. You don't know when that money will be recalled. Additionally, Your Honor, you could exceed 12% if there's no encumbrance on that money. Some sophisticated businesses could. And the rule shouldn't shift or go up and down when the rates of return on CDs go up and down. What Massachusetts has adopted specifically, and what has survived every challenge by other defendants at the SJC, is no, we want a black line rule of 12%. There is a way to end that, and that's to simply get an appellate bond. Go and get an appellate bond. But instead, what the defendants ask here, they want you to ignore the post-judgment interest statute and make the plaintiff their bondsman so they can avoid the fee. That's all this is. And the true avenue in the flow chart that this court should view is that when these judgments are affirmed, because they're all either waived or they have no merit, plaintiff has not had actual use of that $3 million. And just like in Safarowicz, just like in Allstate, Davis v. Allstate, and in Gabarno law, that post-judgment interest continues to run regardless of what's happened so long as there's been a condition placed. And maintaining your appellate rights has been affirmed by the SJC.
Let me ask you just one more question. Under your proposed rule, why would a losing party at trial ever make a tender of judgment pending appeal? I mean, in this case, it seemed to be there's an issue about the attachment to property, that they got dissolved. But, you know, if you're pursuing an appeal and you can't, and the interest is still going to run, there's no incentive for the party that lost at trial to ever make this payment to the other side.
Quite the opposite, Your Honor. They could negotiate or mediate post-verdict, and it frequently happens where cases are settled pending appeal because there's an uncertainty on the appeal that the meritorious plaintiff must face. And so sometimes it is settled for less than the judgment amount, sometimes for more than the judgment amount, and good mediators help the two sides to accomplish that. And the biggest pressure to get defendants to actually come to that negotiating table is 12% interest is accruing. That's why the SJC has time and again said in Massachusetts, we prefer that policy in place. It's not punitive, said the court in Green versus Philip Morris and also in Gabarno and Safarowicz. It's appropriate. The legislature itself has reviewed the court's holdings on those and never changed that statute because that is what Massachusetts prefers. It helps parties resolve cases after verdict. And again, the appellate bond is the simple two-word answer here that would be the solution in this case. Get an appellate bond. But they want to make the plaintiff their bondsperson, and that should not be appropriate. There is a condition on the remaining $3 million. The final issue is the issue of the final fee award, we'll call it, the post-rescript fee award for the litigation that occurred after rescript. And the questions from the court were spot on before, but I just want to note there's a direct waiver here. There's an absolute waiver on this final issue. These two arguments, one that the contract has an event of default only limitation or that 93A doesn't apply, they were raised. The first in 2018 to the first contract-based fee award, the second in 2019 to the first 93A-based award, and they were denied by the trial judge. That became the law of the case. And
but that's not waiver as to I understand what you're saying. There's no issue like because they didn't pursue that on appeal as to those awards, as to this new post-rescript award, maybe they're making the same argument. They dispute that, but it's a new post-rescript event that's now on appeal. So I don't see why that's a waiver.
Well, let me elaborate then, Your Honor. If you look at the supplemental record appendix that we submitted, we put their arguments in, and they're virtually copy and pastes to the same argument, Your Honor. And it is, under liquor liability joint underwriting versus Hermitage, a doctrine called law of the case that when a trial court has made numerous decisions in a case and they've been decided, they're
Right,
not
so
to...
that's not waiver. You may be be repeating an argument you made earlier, and as a result, you may lose on it, but by making it, you're not waiving it.
We would argue that...
Why don't we assume that that's not waived?
Okay. Yes, Your
And go to
Honor.
the merits of it.
Trial court was correct to deny those in 2018 and 2019, and they should be denied now for this reason. First, on the contract basis. They must, by the way, succeed on both avenues, the contract and 93A. The contract says any and all litigation, transactional costs, it's any and all. And the cases in Massachusetts interpreting whether it's a broad allowance of fees or a limited one looks to the language of the contract, and we cited all the cases in our brief are any cases that say any. Ours goes broader and says any and all. The cases cited by the defendants are all limited fee provisions. Limited fee provisions.
It does seem a little bit weird that where the argument is that there's an underlying error, which there were underlying clerical errors, that that's supposed to be chargeable to, that pursuing that should be chargeable under either one of the fee shifting mechanisms. Normally, fee shifting, it doesn't really seem to promote the idea behind fee shifting to charge people with the cost of correcting the court's mistakes.
And the trial court already did what Your Honor proposed before and went through the petition, which is in our record appendix, supplemental, which showed that the initial request was over $97,000. And the amount awarded, the trial judge went through those entries. The trial judge took out those issues, and I think it's around $52,000 was the ultimate amount of the award. And the Majestic took out significant ones before it even went in there. It was twice reduced beforehand to address exactly that issue. And Robbins v. Kroc states specifically, in any fees clause in a contract, and here we have any and all, covers everything, even after, including, in that case, collection, past where we are in this case. On 93A, also, it's absolutely secure. The argument essentially rejected in 2019 and raised again here in this latest 93A fee award is that only if the item itself was unfair and deceptive, not the post-rescript issue itself. And that's not the law. That's not the law. The case of Ross versus Continental says specifically the opposite. All other trial court actions, in addition to the unfair and deceptive event of default or whatever it may be, all other trial court actions reasonably necessary to obtain a final judgment. So there's two independent bases for the validity of that final fee award. And on each of them, the trial judge should be affirmed. By failing to raise the apparent issues on the first judgments in the earlier appeal, the defendants waived them. So there should be no challenge whatsoever on the merits of prejudgment interest on the delay damages. And the trial judge was correct on the merits on those issues because they were all already incurred delay damages. They were reduced to present value at the time of the beginning of the lease. That's what's missed in the defendant's merits argument there. With respect to the post-rescript items, again, Davis versus Allstate, Commerce versus Safarowicz, Gavarno Law, they all look at it, and if they see any condition, including maintaining one's appellate rights, the policy in Massachusetts, upheld in those cases and deemed to be fair by Justice Gantz, and again recently by Green versus Philip Morris, is that Massachusetts endorses that view, that policy, because it does create resolution post-verdict. Because of that policy and the SJC's decision to uphold it, those decisions of the trial court should also be affirmed. And then finally, there's both a contractual and a 93A independent basis to uphold the final fee award. For that reason, all of the awards, all of the decisions of the trial court should be affirmed, and Majestic should be awarded its appellate fees for these two additional appeals. Thank you, Your Honor.
Before you leave, I'm just going to check to see there's no further questions. No, nothing to add. I see no questions. Thank you for your summation. Thank you both very much for your arguments. Appreciate it. No, let's not take a break. Oh, that's all right. That's okay. We'll just do the last case.
Let's do it.
Let's do it. We're actually going to, if the parties are here for the last case, we're going to not take our break so that you don't have to wait any longer. I see that they're both here, so let's call the last case on the list. And thank you all for your patience.
No breaks.
All right, so the last case on our list, I just want to say, before I go, safe ride back to Springfield for those who came from the west and are leaving now. The next case is 2023-0470, AB versus SS.
Good morning, and may it please...
One moment.
I'm sorry.
That's okay.
Wait a minute. Is everyone at the right table?
Yeah. Yeah, we have the appellant, right?
But is she standing up from the appellee table? I don't get it.
All right, let's start by introducing yourself, so make sure that we have looks like we have somebody else listed here that's going to be arguing. So, you represent whom?
Thank you. I represent AS. My name is Christina Paradiso. I submitted a substitution of counsel last week due to an unexpectedly early family leave taken by my brother counsel.
Okay. That explains that.
And you're the appellant. So you're representing the appellee? You're on the I just think people are at the wrong table.
Oh.
It's my understanding that AS is the appellant. We brought the appeal.
Yeah.
AB. Yep, AB. Okay, I think you just need to go over to the other table.
Okay, and I remind everybody this case is partially impounded, all right? Thank you.
Thank you. If I may begin. Good morning. My name is Christina Paradiso, and I represent AB, the appellant in this case, and I will refer to her throughout as AB or wife due to the impoundment of this matter. In this case, the district court erred by applying the incorrect standard at the extension hearing of AB's abuse prevention order. The correct legal standard requires that a plaintiff in AB's situation show that she continues to suffer damage from the assault she endured, not that future abuse is imminent. In Massachusetts, abuse forming the basis for an abuse prevention order pursuant to 209A is defined in 3 separate categories in Chapter 209A, Section 1. The first, Section A, is attempting to cause or causing physical harm. The second is placing another in fear of imminent serious physical harm. And the third category, C, is causing another to engage in sexual relations by force, threat, or duress. The SJC further construed the statute regarding extension to give clear guidance in IMLE in 2005. In IMLE, the SJC said that the criteria for obtaining an extension are similar to the criteria for obtaining an initial order. Therefore, we must relate back to the basis of the initial order in order to determine how to and what to look for at the extension hearings. The court did note, and much dicta is taken up in the IMLE, that in that case, relief, as is typical, was sought under subsection B. However, in the case, AB's case, relief was sought under sections A and C, which has a very different purpose and a very different standard.
And that standard was argued below, and especially in the motion to reconsider, correct?
Yes.
Okay, and the judge did not really actually indicate the basis for the ruling, but simply endorsed the motion. So
yes.
Would you agree that we don't really know what standard the judge applied? Or do you maintain that it was, no matter what, the incorrect standard?
I would maintain no matter what, it was the incorrect standard. However, as Justice Blake noted in the Idris I versus Hazel H case, 209A cases are unique. And so I would refer you back to 2 hearings prior to that November hearing in January when the plaintiff appeared pro se. The court spent much time going over all of the factors that seemed to be concerning the court at that time. So there were topics such as saying that the judge was looking for imminent harm. He says it's a horribly nasty situation between these 2 people. He says you need to think of the little child involved. He described the energy and angst that he could see between the parties.
This is the 2022 hearing?
The January hearing, yes.
Let's assume for the moment the judge used the incorrect standard, or at a minimum that it's not clear if the judge used the correct standard. What would be the relief that we could give? We don't issue orders in the first instance ourselves, obviously. So it would mean vacating the denial, but how does that work? It's been more than a year. What do you think would happen or should happen?
There are 2 possible courses. The first, maybe the preferred method would be to vacate the vacating of the order that occurred in May. And then, if necessary, remanding for a further hearing in front of a different judge.
So that would effectively reinstate the order,
Yes.
in your view? Okay.
No, well, but it wouldn't reinstate the order because that order had already expired.
Respectfully, no. It was meant to be heard and considered that day. So at the moment it was being
Right, but
heard-
it's expired now. So reinstating that previous order wouldn't give any protection.
Respectfully, I believe it would. If you look at the IMLE case, that is what happened in IMLE.
But wasn't it still within the time period of the previous one? No?
I don't believe so. In IMLE, the SJC noted that they were vacating the vacating of the restraining order, and they said that judicial discretion is not so broad as to allow a judge sua sponte to vacate the original order. And that is what seems to have happened here, is instead of allowing it to expire or not extending, the district court vacated the order, which we contend clearly he had no basis to do.
Okay, so again, even if we reverse that, that doesn't, since the date on that previous order is long past now, what does that really get you as a practical matter? That, I would assume that's not the only relief you're looking for, is to reinstate what is now would be an expired order.
Although we may differ on whether vacating it would lead to an expired order, I contend it would be an extant order. However,
It's expired now. It would not be as of today. No matter what we reinstated, it would be expired as of today, correct?
not, with all due respect, no.
The improperly vacated order, what was its termination date?
It was the date of the hearing.
Which was May 5th or in May 2022?
Yes.
All right, that's quite a while ago. So even if we reinstated it, it would only get you an order that would expire in May of 2022.
With all due respect, what should have happened that day was a hearing should have been held with the proper standards.
Correct.
And the proper considerations, and then a permanent order, we contend, should have issued.
Okay, I understand that's your argument. We can't, I think we already covered this, we can't issue an order in the first instance ourselves. So again, I go back to, what would you want for relief?
I think I understand the problem, Your Honor.
I'm looking for help from you.
Yes, I understand. And this is a problem common to many appeals in 209A cases in which the order is not extended. This is the problem that our clients face on
If we
appeal.
agree that there's an error, we're looking for some kind of meaningful solution. I'm seeking your help.
Yes. And I'm sorry if I'm not providing that help, Your
Well,
Honor, but
no, I mean, because we can't issue orders in the first instance ourselves, so we're not going to be able to issue a permanent order, we're not going to be able to issue a one-year order, we're just not going to be able to do those things. So if we vacate the vacator of the, I guess it would have been an earlier, January 2022 order, because it was short, right? It wasn't a full year. That doesn't get you much because it gets you through May of 2022. So do you want a hearing? We would remand for a hearing on the right standard.
yes, that
Okay.
is certainly what we
I
would.
think that you're saying that the order would still be in place, even though is that what you said when you said that it would be extant? Because that's what happened in the other SJC case.
Yes.
That's, okay.
Yes, we are seeking the protection to go at least through any remand hearing.
Through a
For
hearing.
another hearing.
Right.
Yes. So it is apparent from the record that the district court took into account many irrelevant factors, including looking for imminent harm. He also was talking about the fact that the parties have a child together. And some of those things are relevant in the opposite way from the way the judge dealt with them. The judge used those things as reasons why the order should not go into the future. He said that, they can't get away from each other, they're dysfunctional, they have a toxic relationship, and they share a child together. And those are typically seen as reasons why an order would extend, not be terminated or vacated. The parties were involved in ongoing litigation in the probate and family court. There were also pending criminal matters against the restraining order defendant.
Can I ask, can you think of any circumstance under which a pending custody litigation would be relevant to a 209A hearing?
It's relevant only insofar that it stirs up the emotions and may increase the conflict. It also, because they do share a child together and they are going back to probate and family court, it also means that they will encounter each other again repeatedly, and perhaps, for the next 8 years or so, depending on the age of the child. But it should...
Here the judge said, well, I want to see what happens in the custody proceeding before I issue a ruling on this issue. I'd be interested in your thoughts about that. Could that ever be appropriate?
With all due respect to the district court, no, it should not have been
Well, it
handled
could
in
be,
that way.
I mean, it could be with respect to determining the terms. In other words, the probate and family court could also be issuing orders such as regarding visitation, use of the marital home, something that there can't be inconsistent provisions between what the probate court is ordering the parties to do and what the terms of the 209A order might be. So I think with all due respect, what's happening in related litigation can and should be taken into account by the judge before issuing the terms of any restraining order here.
In a different way than what occurred in this case. I agree with Your Honor's point that, of course, the restraining order could be modified to reflect whatever terms the probate and family court have entered regarding custody or return of marital
Right.
property, but not to look to the probate and family court events as guidance as to whether there were still safety and protection concerns. That has flipped the reasons why you would want to know if the parties have a child together or are litigating somewhere else. It's not to see whether whether they are able to reconcile or whether they are able to work out an agreement in the probate and family court. The judge should have been looking to those things to determine whether they would encounter each other in the future and whether the hostilities would increase, and not viewed in the manner that the court appeared to do it. As in Noel versus Frazier, F, all of the factors presented by AB should have been taken into account, and the entire history of the parties' relationship should have been considered when the judge was deciding whether or not to extend the order. Instead, there seems to have been great confusion reflected in the record as to what the standard was, what evidence the court was considering, and certainly based on the judge's comments that did appear in the record, it would appear that the incorrect standards were used. And so for those reasons, we are asking for the vacating to be vacated, for the protection to extend through the time of a remand hearing, and for the remand hearing to be held in front of a different judge, if possible. And
Any further questions? Thank you very much.
thank you. If there are no further questions, I rest upon my
I
brief.
just checked with the panel and we're satisfied. Thank you.
Good morning, Your Honor. Karen Wayne on behalf of SS. I would definitely argue that the court did not make an error in vacating the restraining order. This has been very contentious. I do not represent SS in the probate matter, but I've had extensive conversations with her. This restraining order was a result of a custody battle on behalf of AB, to the point where visitation had to be at the police station. Now, the probate and family court can certainly overrule a district court restraining order and make any amendments that they want, but this judge decided to vacate it based on the fact that the AB did not have any physical contact with SS at the time of the hearing since the last court hearing. There's been several court hearings on this matter. So how can she be in fear of any kind of harm, imminent harm, serious bodily injury, if she's had no contact with him? And she admitted that on the record.
That's a difficult standard to apply, isn't it? Because if a restraining order is working, then there is no contact.
Right.
So it's hard to prove, it's hard to prove that the lack of contact means that there's no danger, as opposed to simply the fact that the restraining order is working.
Well, she dropped off the child many times to SS at the police station, so there was contact many times, and yet she was not in fear of him at that time. There's been no issues at all. So I would suggest there has been contact, but no physical contact. And at the motion to reconsider, over the course of several hearings, and again finally in May this year, they've been before you, and not only with all kinds of documentations. And what also happened when AB, during all this time, was taking out several charges against SS that were either dismissed or not guilty. Every single time. I would say this was very contentious.
Would you agree that what the judge was looking for and wanted to know, in fact, I think at one point he says, what I want to know is if there is a risk of imminent physical harm?
Right.
Okay. And do you agree are you saying that's the proper standard?
I do, Your Honor. Risk of imminent harm, risk of serious bodily injury is the standard on a restraining order to extend, especially as what this court said in Danny D. versus Eli in a companion case, which I think is very important.
Well, that's not what we said in Yana Y. versus Sylvester S.
Right.
right? We said that in a case like this, when the underlying issues are a sexual assault, that's not the standard that we look at.
But in, Your Honor, with all due respect, in Daniel D., it was a harassment prevention order, and in that case, they said that the plaintiffs were not required to relitigate the harassment on which the prior orders were based, but they were required to prove an ongoing need for protection.
Was that a Chapter 2, was that a 258E?
That was, yes, Your Honor, that was a harassment prevention order. AB is not proven to the district court that there was anything, that there was nothing, there was no new evidence. Every time there was an extension, it was based on the same 2018.
Hypothetically, if we were to disagree with you and say that the judge either, it's not apparent on the record that the right standard was applied,
Right.
or it's apparent that the standard is incorrect, either one, if we were to come to that conclusion, what do you think should happen?
Your Honor, I think it should be vacated. This divorce is final. There's no more divorce yet. They're going back for support issues as well. There hasn't been any issues between the parties. They do not converse together. I would just say leave it vacated.
Well, that would, if the judge used the wrong standard,
Right.
we would vacate the judge's ruling on that was made on an incorrect legal basis.
Right.
And then wouldn't you need to go back and have a rehearing on all the evidence you just mentioned? We can't take evidence here on that evidence, and then the judge would decide whether or not to issue another order or not, or whether the need for the order has disappeared.
Yes, Your Honor, but what would happen is we'd be back to the same original, the first restraining order where she said that she was assaulted by SS, and that's all the evidence there is. There was nothing more than that.
Right, I understand. We can't relitigate that, but we can, our job is to make sure that the trial judges use the right legal standard. So if the judge didn't use the right legal standard and we remanded for that, then I take it in your view there would be a hearing in which you would present countervailing evidence or evidence to go against the idea that any order is any longer necessary.
Yes, Your Honor, but I would suggest the judge did use the correct standard, that there was no evidence presented, no new evidence presented at the extension hearing that she was in any danger of physical harm.
Right, I understand your position on the law is that the judge got the law right.
Yes.
Judge Vuno's question was, if we disagreed with you,
Right.
what would be the procedure?
But the procedure would be that
Go back and have another
AB
hearing?
would have to go before,
Yeah, you'd have to have another hearing.
Yes,
She'd have to
yes.
satisfy whatever her burden was under the correct procedure,
yes,
correct law.
correct.
Okay.
I think.
Right? I think we understand your position.
Thank you, Your Honor, and I rest on my brief.
Right. Thank you both very much, and thank you for your patience staying to the end today. We appreciate it. That's the last case on for today, so the court will stand in recess. Thank you.